be informed by the Honorable Isaac Ruto?
I don't think so, Mr. Chair. I know my friend's disposition. I would rather he holds his peace because I don't want to be long.
Proceed.
I actually
Can you conclude now?
Yes, I actually must conclude by saying this is very healthy debate. And we know the rules. We know the Constitution. All of us have sworn to uphold this Constitution. The reality of devolution, which is a very exciting thing to me, is here before us. But let us also accept the fact that the President has acted in accordance with the Constitution. And therefore, Mr. Chairman, I think we should move on with the business. And I also, the last point I wanted to make is when the Deputy Prime Minister, Minister for Local Government, brought this matter before the House, and indeed is still the one shepherding this process. He is acting within the understanding of one government. There cannot be two governments. Thank you, Chair.
The Honorable Shebesh, I'll take 3 more and then give a direction on that. Shebesh.
Mr. Speaker, thank you very much, and I want to apologize for earlier behaving like I was in high school. Mr. Speaker, that is not what I was intending. However, Mr. Speaker, I was getting very perturbed by the remarks that were coming from this floor. It was actually reminding me of the days that I was in high school, so maybe that is why I was confused. Mr. Speaker, I just want to speak on one issue. This issue of using the presidency to whip emotions is very, very unfortunate by the Attorney General, by the Minister for Justice, and even our chair of the Oversight Committee. We respect this president. That is why we want to debate this issue. That is why we have not taken this issue outside this House. To purport that we are bringing politics into this issue, Mr. AG should know that this is the heart of politics. This is the political heart of Kenya. We are in Parliament, and this is our work. Mr. Speaker, definitely the presidency is an institution. It is not an individual. And we are definitely being reduced to think about the president, Mwai Kibaki, rather than the presidency of this country. And he will not do it because we are not children, Mr. Speaker. We know the game that is being played. When AG was speaking here, he spoke about voting 3 times or 4 times in his statement. He kept going back to vote. Mr. Speaker, we can see that the voting machines have been called. We know them. They never come here. Some I've not seen in a while. In fact, when I leave, I will greet them because I haven't seen them in a while. So, Mr. Speaker, what I'm saying is...
Can you... Order.
Let me just finish, Mr. Speaker.
Order.
I will remove the word voting machines, Mr. Speaker, and I will say this, Mr. Speaker, that the presidency is advised by 2 very important organs, the Attorney General and the Minister for Justice. And therefore, to purport that this decision was made by the President alone in his own thinking is also to mislead this House, Mr. Speaker. And so I want them to be candid enough to say that they misled the President and that they are willing to go back and take the point that Gitobu Imanyara has brought, because if it comes to, on the face of it, I don't know what you say in the lawyer terms, who is trusted right now on talking on constitutional matters between the AG and Gitobu Imanyara, I can tell you Gitobu Imanyara will take it hands down.
The Honorable Mbadi.
Thank you, Mr. Speaker. Mr. Chairman. Mr. Chairman, when I listened to the Attorney General, I realized that Kenyans made one mistake of removing the security of tenure.
Order. Honorable Mbadi.
Yes.
Confine yourselves to the merits and demerits of the matter that's before you and before the House.
Mr. Speaker, I felt I should have said that because, Mr. Speaker, I saw the Attorney General who did not believe in what he was saying. But, Mr. Speaker, let me go to the fundamentals of what is being discussed this afternoon or this evening. Mr. Speaker, I think what we need to ask ourselves, and that is what the Honorable Gitobu Imanyara raised, is whether this House can proceed, debate, and take a vote on a matter, on a memorandum that we feel is strongly based on wrong premise of the law. Mr. Speaker, or Mr. Chairman, the gist of the memorandum is to try to question the amendments that this House did make, in which the President is talking about restructuring the national government, and then he's restructuring the provincial administration. And Mr. Speaker, he goes ahead to say that this is the function of national government, and by extension, trying to explain to us that Parliament is not national government. Mr. Speaker, if there is no wrong interpretation of the law, I think that is the worst interpretation of the law. And we cannot proceed on the basis of misrepresentation of the law by the President. And Mr. Speaker, what we are asking this evening, what we are asking the Chair to do, is to find that the motion before us that we are supposed to debate is based on wrong premise of the law. Mr. Chairman, I want to just take the House to Article 239. And that article says, 239(5), and it says that the national security organs are subordinate to civilian authority. Mr. Chairman, my understanding of this is this. Civilian authority at the county level, the county government, is exercised under the governor. And if you have subjected or subordinated the security organs to his authority, then you cannot say he cannot chair, that he has no role to play in security. Mr. Chairman, the argument that was brought by the government about the people of Kenya and consultation, I want to remind the Attorney General that the sovereignty of the people of Kenya is actually the first article of this constitution. And it says that all sovereign power belongs to the people of Kenya. But it goes ahead to say that that power can be exercised either directly or indirectly through democratically elected representatives. And there is no democratically elected representative organ of this country superior to Parliament. And as we speak here, Mr. Speaker, we are perfectly in order. We are perfectly in order to legislate on behalf of the people of Kenya, because we have derived the sovereign authority from them, which cannot be questioned. And therefore, I would just urge the Attorney General and say exactly what Honorable Martha Karua said, that please let us not argue too much on this matter, because it is very clear. Let us accept that probably something was not done right. Withdraw. Ask for withdrawal of this bill, like you did graciously to the finance bill. Take it back to the President. Sit with him. If you need to consult, you can consult some of us, especially Honorable Gitobu Imanyara, because he came out very well that there is something probably he knows, which you also know, but you missed. So, Mr. Chairman, that is my plea to the government side.
The Honorable Deputy Prime Minister.
Thank you, Mr. Chair. I want to argue from a completely different perspective and not a legal one, because that is not my domain. But I would like to appeal to the members to consider one thing, that the more we prolong resolution on this issue, the more we delay the process of activating a number of issues regarding devolution. We would like to start making serious plans on the budgetary processes and how to help the county governments start when they start. And therefore, I would like to request the members to consider the fact that we need this law to help the Commission for Revenue Allocation, to help the budgetary process, so that we can start working on specific legal mandate in preparing for the finances that should be able to kickstart the county governments. So I think in making the decision, Chair, please consider the fact that there's also an important process that needs to be triggered off. The other aspect that I would want to point out is that if we had had time to also look at the order paper and the way it is being proposed, you will find that we are finding a solution which does not negate the role of the governor. We are finding a solution which still comes out very clearly that the governor, it's already recognized that he's the chair of the county policing authority under the Police Service Act. It's law. So you cannot change that. The governor is already the chair. What we are doing here also is to just add further and create another body, an intergovernmental body, which allows the governor to go even beyond chairing the county policing authority, but to also chair a forum of all the heads of department in the county. And at the same time, his role under Article 4.1 of the Police Service Commission Act has not been negated, and it's also been recognized in this proposal that we are putting before the House. Equally, I'd like members to remember that the committee, the relevant parliamentary committee, has also been seized with this matter. It has also dialogued, and we have, and we did even contemplate that would we have the 2/3 to completely negate the presidential memorandum. The reality of it is that after a lot of consultation, we realized that we will not get the 2/3. So rather than create a deadlock, I would like to plead to the members of the House that let us move forward, because as we move ahead, the law that is going to restructure the provincial administration is going to come here. And that will give members the opportunity to, if I may use the surgical blade that this House has, to critically look at that law and what will be obnoxious in the national administration law, which may be infringing on the territory of the county governments, can then be dealt with at that time. But please, honorable members, we must activate the county system. The more we delay this, the more I feel that we are indirectly playing into the hands of those who are not for devolution. So I would really want to plead that let's rethink our position and then move forward so that we can activate county governments. With these remarks, Mr. Chairman, I propose that we move ahead.
Thank you very much, Chair. I will not go into great lengths to the arguments that have been ably argued, Mr. Speaker. But I want to remind us, Chair, that the question of devolution is at the very heart of the campaign for constitutional changes. And Mr. Speaker, the role of the provincial administration, the office of the President, throughout the last 50 years, Mr. Speaker, has come into great question. And it has created the impetus for the change that has been demanded all along. Mr. Speaker, today, this afternoon, we are not questioning the constitutional power of the President to give us a memorandum. It is clearly enshrined in the Constitution that he has that power. We are not arguing about that, and in fact, that is why I wanted to inform the Vice President that we are not arguing about his powers that are clearly put there. The question is, the issue before us that he wants us to assent to in his objections is actually the particular matters that are not constitutional. And I don't think we are obligated to just agree with the President because he has powers to give us a memo. The memo must make sense in law and in fact. Once it is clearly proved in the plenary here and everywhere, every right-thinking Kenyan can see that this is in contradiction with existing laws, Mr. Speaker, Mr. Chairman, I think it would be very strange for Parliament to just go ahead and say, because the President has sent it and you need 2/3, we just accept. Mr. Speaker, it will send the wrong signal. And I want to urge the government to be very careful. I know I'm persuaded by the views by the Deputy Prime Minister, but nevertheless, Mr. Speaker, Mr. Chairman, I want to request the government not to paint the presidency as a home for regressive forces that are now coalescing around the presidency as a last bastion against changes that Kenyans have yearned for over 50 years. Mr. Speaker, this kind of view is now getting currency all over the place. That look, you are only going to hide behind the presidency so that you hold on to a very regressive system called the provincial administration that has actually, it operates like an occupational force throughout the country. They are a law unto themselves. We have established a national security organization under the police, who Who are these other fellows you want to insist that they must exist side by side with elected leadership at the lower levels? Why did we yearn for constitutional changes if we actually meant to retain the same? Where are we heading to, Chairman? Or Mr. Chairman, sorry, I withdraw the Swahili one. I am saying, Chair, that we are persuading government to be open-minded. You only have 7 months. Why do you want to paint yourself very ugly? Huh? I thought you want to come back, or don't you? Kenyans are yearning for changes, but you are now yearning to retain the status quo. Did we pass the constitution so that we remain the same, or so that we can improve?
You voted no.
Because I didn't want to have measures that we are seeing here, including giving us 15%. When during our campaign, we were talking about 40% of the resources. Look at the finance management bill that you have given us here. You are also putting even more problems in the other finance bill. Where are we heading to government? Let us be honest to ourselves. What do we want to achieve? What did we set out to achieve on constitutional changes? So that we remain the same? Chair, I want to propose that the president be properly advised and that he withdraws this memorandum. We cannot be persuaded to vote for it, even 20 of us. We may not get 2/3 because we know they have the capacity to run away from the house so that we don't get the 2/3. But we will pass the message that we are not interested in this type of gimmicks. Thank you, Chair.
Order. The Honorable William Ruto. Order, you will have your moment.
Mr. Speaker, thank you for, Mr. Chairman, thank you for giving me this opportunity. I will go straight to the point, Mr. Chairman. At issue here is really not the merits of what the President is saying. I think you pointed out earlier. The issue here is, does the standing orders apply to the President? When the President is making a recommendation to this House, does he have to comply with the standing orders with respect to his proposal? When the President is making his recommendation to the House on changes on a bill that has been passed by this House, does he have to comply with the standing orders? That is, does his recommendation need to comply with the provisions of the standing orders, that he cannot make a recommendation that negates what was passed by Parliament? I think that is at issue. Secondly, Mr. Chairman, and if the President makes a recommendation that negates what was passed by this House, and therefore is in contravention to the standing orders, what is the position of that recommendation by the President? Yes. Mr. Chairman, I think really that is the issue we need to resolve, so that the issue of is it constitutional, I think this is the issue. And Mr. Chairman, this is going to be a very serious issue, which I want to plead with the Chair to really apply his mind to it, because it is going to set a precedent. It is going to set a precedent. You will notice, Mr. Chairman, that when the DPP and the Chief Justice and the Attorney General were proposed, the contest there was the provisions as put in the transition clauses and the provisions that were in the Constitution. Here, Mr. Chairman, you are faced with a situation where you have to set a precedent, so that in future, if the President must comply with the standing orders with respect to not proposing recommendations that contravene or negate what was passed, and that even the rule of unconstitutionality applies to the President in the making of the bills, in his role, because the President has a role. And Mr. Speaker, this is your opportunity to provide guidance to the President, so that in future, if he has to make recommendations, they have to comply with the standing orders, and they must be in tandem with his authority given to him by the Constitution to participate in legislation through recommendations of memoranda like what he has done. I think the other issues, Mr. Chairman, are really issues that will go into merit. But this is not an issue, in my very honest opinion, this is not an issue that we can vote. This is an issue that you need to make a decision. Fair enough. And Mr. Speaker, let me conclude. Let me conclude by saying the following. If you find that the president must not necessarily comply with the standing orders, then we can go ahead and debate and put it to vote. But Mr. Speaker, I think we are all in the process of establishing a new way of doing things. And your office, you're called into the fray now to provide guidance so that even for the president, we are not saying the president has done anything illegal, even for the president in future and those who advise the president, whenever they will be making this memoranda, they will be careful to follow what the guidance of the chair is.
I am going to take one final submission from Derito and very finally, the Minister for Acting Minister for Finance, because he's a legal mind. And please confine yourselves to the merits and the demerits of the matter that's before us.
Thank you, Mr. Chairman.
Point of order.
Mr. Chairman.
Point of order. Are you on a point of order, Honorable Onyonka? Yes, proceed, Honorable Onyonka.
Mr. Speaker, I don't know how to put this. The problem I'm having, because in reality many of us are not quite versatile with the law in terms of interpretation, would I be correct, Mr. Speaker, if we were to request the Attorney General to make a clarity as to whether the interpretation of the issue is based on what happens if this law was passed in terms of the powers which the head of state will have vis-a-vis what powers that the governor will have.
And Derito.
Point of order. Thank you, Mr. Chairman. Point of order. Mr. Chairman.
Yes, Honorable Konyela, are you sure it's not a point of argument like the Honorable Onyonka?
Mine is a point of order.
Yes.
Mr. Speaker, the Speaker of the National Assembly placed this memorandum before the Committee of Local Authorities. And the committee interrogated and called all witnesses to address the interrogation, and the members need to be enriched by what the committee found. So in order to request that the Committee of Local Authority be given a chance to let the House know what we found.
Order. Honorable Matters, you must address yourself to the core of the matter. The core of the matter itself is the constitutionality of the matter before the House. I recognize there's a lot of debate on many issues, but clearly try and confine yourselves to exactly what is at hand. Proceed, Honorable Nerito.
Thank you, Mr. Chairman. Mr. Chairman, you notice that in addressing this question, most or many of the arguments that have been placed before you have dealt in one form or another about the intentions to restructure or otherwise the provincial administration. Mr. Chairman, you will also notice that in the bill, that is actually dealt with by clause 54. Yet the many arguments, Mr. Chairman, that have been presented to you have tried to use Article 30 or Clause 30 and in particular focus on one specific sentence that refers to there is no county equivalent of the National Security Council. So I think, Mr. Chairman, it would be useful to go into what is actually the National Security Council and which functions are contained in this particular organ. Mr. Chairman, you will notice there are 5 key functions. I'm not talking about persons, but 5 key functions represented in the National Security Council. Foreign Affairs, Mr. Chairman. immigration, Mr. Chairman, defense, Mr. Chairman. Can we truly argue that these functions will have their equivalents at the county government? My humble submission to you, Mr. Chairman, is that we cannot. Because indeed, these functions are the functions of national government, and that is why, Mr. Chairman, even in framing, Mr. Chairman, that at the county level, there is an equivalent dealing with policing, Mr. Chair. That is internal security, Mr. Chairman, which is a function represented, yes, in the National Security Council, but is only one function. The last function, Mr. Chairman, is finance. So, Mr. Chairman, I think to base the whole question of the constitutionality of this memorandum on the simple question of whether there is in fact an equivalent of the National Security Council at the county level, I humbly submit to you, Mr. Chairman, is erroneous. Yes, can you conclude? As I conclude, Mr. Chairman, yes, and I think most members agree that the governor elected by the people of that county surely has a role to play in the policing of that county and in providing other functions that go with policing. But that is not to say, Mr. Chairman, that those roles are equivalent to the National Security Council. Thank you, Mr. Chairman.
Can I take exactly 3 minutes, no more than 3 minutes?
Thank you, Mr. Chairman.
Give direction on this.
Thank you, Mr. Chairman. Mr. Chairman, I've looked very carefully at the President's memorandum, and I don't see any contradiction at all. Mr. Chairman, the framers of the Constitution, in their wisdom, placed national security under the national government, and for good reasons, Mr. Speaker. Because, Mr. Chairman, I think what the framers of the Constitution had in mind is that if you put national security under county government, and you get a rebel governor who may want to declare their county independent, that was exactly the reason why that national security was placed under national government, and that's exactly what the President is saying. Secondly, if you look again at the functions of the county government, national security is not one of them. Again, for good reasons. If you go to the schedule, Mr. Chairman, it says that the provincial administration will be restructured within 5 years. Be restructured, not abolished, Mr. Chairman. It's going to be restructured. Thank you, Mr. Chairman. Again, I've looked at the President's memo. I don't see what is negativing about what the amendments that the House passed. Therefore, Mr. Speaker, to me the solution, Mr. Chairman, is that we now discuss the merits of the President's memo. If we don't agree with them, we raise 65%, we override them, and then what originally the House passed passes. If not, then we accept. If we can't get the numbers, then we accept the President's memo, and we move on. We need this county devolution as a matter of urgency. The President is on record supporting devolution. Treasury is on record supporting devolution. Everybody is supporting devolution. There is nobody against devolution. Thank you, Mr. Chairman.
Mr. Speaker, I think enough has been said, and I don't want to dwell on the matters that have already been touched. But you know, when you start picking on every other aspect that members spoke to, the memorandum of the President stands almost deleted, because every other aspect has been termed erroneous. And even when Honorable Gidai and other members stand here and say they do not see any contradiction, Mr. Speaker, Mr. Chairman, the standing orders say that someone shall be entitled to the statements of facts that are made to this House, Mr. Speaker, whether in oral or in any written submission, Mr. Speaker. So, Mr. Speaker, when a memorandum comes from the President and contradicts the facts that are enshrined in both the Constitution and Acts of Parliament that the President has assented to, Mr. Speaker,
Should we just accept the memorandum, which is defeating the facts that are in this House, Mr. Speaker, merely because it comes from the President? Because, Mr. Speaker,
point of order.
When the issues have already been raised,
point of order,
that
point of
the
order.
memorandum of the President,
point of order,
is
Mr. Chairman, my good friend spoke to point out that on a point of order, but he's again now debating it. If he's debating and you are reopening the debate, then let us, for heaven's sake, allow the debate to continue.
What indeed is out of order?
I was contributing to the issue of Honorable Gitobi Manyara. That
you had your moment to contribute to the
No, Mr. Speaker, I haven't.
Okay, proceed.
Yeah, Mr. Speaker, I haven't. So, Mr. Speaker, because we have already talked on the issue that the President's memorandum is erroneous in denying a fact that there is a county equivalent of the National Security Council, which he himself, Mr. Speaker, accented to. The fact that, Mr. Speaker, the President's memorandum negates the fact that this National Assembly is part of the national government, which by law is entitled to restructure the provincial administration. Mr. Speaker, the fact that the President's memorandum negates the admissibility that we can restructure the provincial administration within the 5 years, Mr. Speaker, and the 5 years have not lapsed, I want to go to clause 1 on page 4 of the present memorandum that says, Mr. Speaker, 54.1 provides that the further structures of decentralization shall include locations and sub-locations. That is what was passed in the bill that the President has rejected. And it says, Mr. Speaker, this is inconsistent with part 2 of the 4th schedule to the Constitution, which leaves the creation of these structures to the respective county governments. Mr. Speaker, I have gone through part 2 of the 4th schedule of the Constitution. There is not any aspect that has been cited that grants the county governments the powers to Mr. Speaker, form any further decentralized units. The only provision, Mr. Speaker, that the President should have cited is a provision we passed in the same bill he has rejected. In the same bill. After we said that the sub-locations and locations will be further decentralized units, we again gave powers to...
I said, mimi sikuji kutafuta kazi, nakuja kutafuta pesa. Those are two different things. Ukitafuta kazi, utatafuta sana. Pende, Michuki John Joroge has given me a new inspiration that a rich man can die. Very rich, when sani yake. Na, atesipariol. Wanawake wajitokelezei tu kila pahali. Oh, huyu alikuwa bwana yangu, alikuwa bwana yangu. Yani, it's been laid to rest in peace. Young men learn about that. Wapi makofi yako?